And now I'm going to share my screen for just a moment, a little introduction to Age-Wise Colorado, who we are, and I'll also be introducing our two panelists today. So we're all about helping aging Coloradans and supporting the caregivers of today and tomorrow. Today's webinar, this is number 49 since we launched this service in July of 2021, so a little under 3 years ago. Tools for your peace of mind, as it says here, and the peace of mind of your heirs as well. A few just quick reminders to, if you're not speaking, if you're not Renee or you're not Lewis, please mute and have your camera off during the presentations. And if you have questions along the way, please put those in the chat. We probably will have some time for verbal questions, but we'll see how it goes. We're doing something a little different today. We're doing more of a question, more of an interview type format as opposed to PowerPoint slides. So I think that'll work just great, but it'll be a little different. And so these are our two panelists. And when we get started, I will begin by asking them some questions. So Louis Osterman is attorney, is dedicated to working directly with individuals and families to ensure their loved ones are taken care of, legacies protected, and their futures secured. Before joining Osterman Law Firm, Lewis worked at a top-ranked civil litigation firm and advocated for patients injured by dangerous drugs and medical devices. This experience highlighted the uncertainties and expenses of litigation, steering him towards estate planning as a proactive way to help families avoid future legal challenges. And Renee Greer is a dedicated estate planning attorney who specializes in assisting individuals and families who recognize the importance of preparing for the future. Renee dedicates her practice to helping her clients make informed decisions that ensure their wishes are honored, loved ones are safeguarded, and legacies are preserved. Her passion lies in working with individuals and families who are juggling the responsibility of raising their own children, as well as caring for their aging parents. As a member of the sandwich generation herself, she's familiar with the complexities and emotional intricacies involved in navigating this delicate balance. And I couldn't say it any better than talking about the sandwich generation, because we aim that's Age-Wise Colorado, age sandwich generation and older. And as it shows right here. So we're here for all those folks. So there are about 3 million people in Colorado over the age of 40, and there are around 3,000 potential service providers. So we connect people to vetted service providers. We have about a little over 400 now on our site. Reliable information and educational events like today. This is a snapshot of our homepage. If you haven't been on our website, please check it out. Educational webinars we have today. Next week, we're having one on if anybody might be interested in being involved in a research project, which is a no-touch, no show-up. You can do everything from home. You can learn more about that. And then toward the end of the month, we'll be talking to some folks who are in the helping people over the age of 50 find work, whether it's unpaid or paid. And these are the longer bios of our two panelists, and they will be included in the recording, and so will that. So that is enough of the introduction. I'm going to stop that now and begin with starting to ask some questions. So start out very generally. I think, Renee, I'll address you first in this one. What is an estate plan, and why do you need one?
Well, an estate plan is a way of taking care of your loved ones, but also providing for your care for yourself through powers of attorney, and both medical and financial, and an advance directive, a will, And oftentimes there may be a trust, but that's not necessarily part of an estate plan. That's when you sit down with an attorney that you'll figure out whether that is a good fit or not. But a lot of times people think that's the cornerstone of an estate plan, but that's not necessarily accurate.
Okay. Louis, do you have anything to add to that?
Yeah, I think that's well said. Fundamentally, an estate plan is just the instructions that you provide to your family, your loved ones, about how you want to be helped while you're alive, and then what exactly happens after you pass away. Um, it's pretty broad. It as Renee, you made a great point. It's not just, oh, we have a trust or oh, we have a will, but it's this holistic, comprehensive set of documents that address multiple different types of scenarios. I suspect we're going to talk about each of those kind of in depth here today. But I think very basically, it's just the answer to the question, what happens?
Okay. And so, Louis, what's the difference between a will and an estate plan?
Sure. So, kind of alluded to it earlier, but the idea is your estate plan is an overarching view of what happens to you while you're alive. And that may include, as Renee mentioned, the powers of attorney, who's going to help you if you're incapacitated. And then after you die, who stands to inherit from you? Is it spouses? Is it children? Is it other family members? Is it charities? That can be, we can use a will to accomplish some of those things after you die, but it is a tactic that we'd use in the overarching estate plan if that's the strategy. A will is kind of an old, oh, I don't want to say old fashioned, but kind of the more traditional way to transfer assets from after someone dies. It uses a court process known as probate, which I'm sure we're going to talk about. Um, and it's optional. So there are ways to put together your estate plan that don't include a will. But I guess I would just make the point, a lot of people come to me and say, you know, we don't want a full estate plan. We just need a pretty straightforward will. And Renee, you're nodding your head, and I'm sure you've seen that a bunch of times. Um, Maybe is the answer. Based on your goals and your priorities, a will may be appropriate for you. It may not be, and that we would kind of work together on to figure out, does that make sense for you based on your estate plan goals?
Okay. Uh, so Renee, could you amplify on that a little bit in terms of cost? So, here's a will, and then here's an estate plan, and they're two, you know, the
Sure.
estate plan,
And I
but
think the question about cost is a very valid concern, especially in today's economy where you go to the grocery store and every single time you go, things seem to cost a dollar more than the last time. So, being financially conscious of that is important, but eh, there unfortunately is no one size fits all approach. It's not a proper estate plan is not a cookie cutter process at all. You have to sit down with in my case, I sit down with my clients and determine what it is that their goals, their concerns, and their hopes and wishes are. What does their financial picture look like? What does their health look like? What are their really, just kind of a comprehensive approach. And from that, we determine what documents and what the strategy is that we want to move forward with. So, I mean, it can be anywhere, and Luce and I were actually talking about this just yesterday, and, it could be anywhere from 1,000 to 12,000 or more. It just depends on what type of strategies you're looking for. Asset protection, are there special needs, Medicaid considerations? So it's very individualized.
And
so the old consulting answer is it depends.
Yeah,
yeah,
unfortunately, yes.
you know, Bob, it's I hate to give the lawyerly answer, it depends, but it does depend. I like to kind of think of it as buying a house. If you ask me what does a house cost, I'd ask you, well, what neighborhood is it in? And how big is it? And when was the kitchen last updated? And is the foundation cracked, or do we just need to maybe update the bathroom? An estate plan works the exact same way based on the features in the plan that will drive the price. And I think Renee and I have similar practices this way. I charge flat rate fees based on the price. It's not hourly for planning work. And so once I know what your priorities are and what features you need, I'll be able to quote you a price, and that's the price, full stop. Um, Again, the more complex it is, the more it costs. But I pride myself on saying, hey, before you even work with me, you'll know what it costs and you can decide if you think it's appropriate.
Absolutely.
So we had a question about a flat rate, I assume for a will. So let's just talk about a will for a second.
Mhm.
Um, so I roll into your one of your offices and say, I'm just here because I need a will. Somebody told me I needed a will, and so I guess I need one. So how much is it going to cost just for a will? Yeah,
Do you
period.
want to take that, Renee?
Oh, well, again, it depends, because in sitting down with the client, you start asking questions. Okay, so, oh, you have two kids and you want everything to go 50-50, but oh, now we found out maybe one of the children does have a disability, and we need to take that into consideration. So it truly, it's not, without knowing more about the situation, it's really not possible to give a concrete answer as to that.
Yeah,
Okay.
I guess I'll just jump in on that as well. So, um, just like Renee said, certainly it depends on what what the will does. A will that says, hey, if you're rolling in with a spouse and we want everything to go to him or her, then that's going to be more straightforward than a marital trust that has remarriage protection provisions in it. Those are different things. With a will, I just want to make the point that whatever you pay, you will also need to keep in mind that for a will to work, you need to go through the court process known as probate. And probate is just what we call a court process for getting someone who has died their stuff to the right people. You need to hire an attorney to prepare the pleadings, to go through and meet the deadlines, check for creditor claims. There's certain requirements that you need. So the cost for a will, I will tell you, in the two kind of main ways to do estate planning, I would say, are you do it with a will or you use what's known as a revocable living trust. We can certainly get into the details of each of those. A revocable living trust, in my practice, costs a little bit more. It does more. And most importantly, it allows you to avoid probate. So some people, and there's reasons you'd want to avoid probate. There's reasons people don't care. We can talk about all that. But I just want to point out with a will specifically, you have to keep in mind that there will be additional costs down the road because of the court process to get the will to work.
So Renee, can you comment on the why somebody would not want to go to probate? More. I mean, obviously you have the cost issue of having to
Sure.
hire an attorney to represent you in probate court, but beyond that, is there anything else?
Well, the just at a very basic level, there's the privacy issue. So a will is a matter of public record. Anybody who is interested can pull it up and find out who your beneficiaries are, whereas um, the trust is not. That's not part of the probate process. It's not recorded anywhere for the public to see. So that's one nice thing. Another thing is the ease of transfer of assets after you've passed away. When someone passes away, the death certificate is provided to the bank. The bank will freeze the assets until they can figure out who the personal representative is, or just directly with the beneficiaries. So there is a period of time where the The family is going to be responsible for expenses associated with the estate. They, most likely will be reimbursed, but that will be down the line. So the trust covers that time frame, and that nothing has happened to the trust. The trust still is in existence and is still operating. Simply, the person passing away is typically a triggering event for the trust to do something, whether it's to make a distribution or whatever the trust documents say. So that's probably the the biggest reason. Another reason is if you have minor children, it's again that money can still be at their disposal, or for their needs. Again, without that stop in the freeze on the assets in any bank accounts. If you have assets in there, and I think we'll be touching upon this later, but assets in your probate estate are available for Medicaid recovery. So if you have anything in a trust, that transfers outside of your probate estate and is not subject to any recovery by Medicaid. I'm sure you probably have some other suggestions or ideas, Lewis, but yeah, there's a variety of reasons. But as you mentioned, there's also sometimes it's not that big of an issue and you don't need to worry about it too much.
So does it depend on the amount of assets that you have then? Is that part of it?
No, Lois, I saw you kind of go to say something.
I guess I'd say it's not so much how much money you have at issue. It's, do you want privacy for your beneficiaries? Again, as Renee mentioned, if you go through probate, it's a public proceeding, which is why a lot of celebrities tend to have trust, because then the general public can't see how much their assets are or what they are, which is also why things like Aretha Franklin or Prince is so interesting. They didn't have estate plans. We get to see those things. Um, it's efficiency. A probate proceeding in Colorado can take anywhere from 6 to 18 months. A trust administration, in my experience, takes anywhere from 3 to maybe 6 months. Oftentimes, you're waiting to just file a final income tax return on April 15th of the next year. And then it's just, do you want, for your beneficiaries, your spouse, your kids, whomever, do you want to front load the work and make things easier for them after you die? Or do you want to say, hey, after I die, I feel comfortable with them putting in some work? Some people want to front load it. Other people, they say, hey, I'll be dead. Someone else can do the job. And those are perfectly, I think, two very appropriate things. There's no, it just totally depends on what your priorities and goals are.
Okay. So in other words, I'll worry about that when I'm dead, type thing. Yeah.
Potentially, with some of these things.
Okay. Well, we'll move on to some other points. We had a question from one person about the transferability of wills, estates, wills, trusts, power of attorney, those kinds of things from one state to another state. And I guess are they transferable, or do you have to redo all of those documents when you move to a new state?
So, in my practice, whenever a new client comes in, or the answer is yes, they are still legal. However, estate planning is very state specific, and there may be some state specific things in other states that Colorado does not require, or vice versa. And so it is best practices to have your documents, all of them, the wills, powers of attorney, living will, updated to whichever state you currently reside in. And then if you move, I like to take that opportunity with clients to say, okay, you've moved. What else has changed in your life since you last updated these documents? Have kids grown up and gone to college? Are they married? Do they have kids? Do you now have grandchildren? Are there deaths or divorce in the family that we need to address? Is there a significant change one way or the other in your assets? and have tax laws changed. So while the answer is yes, they are still legal, there are a lot of reasons why you want to update things if you move.
Anything else there, Renee? You good?
No, I think that says it all.
Okay, thank you. Okay, so next question, we're going to talk about medical power of attorney. I mean, what is that? And then does that remove your decision making if you have named somebody as a medical power of attorney? So Renee, do you want to take that to start?
Sure. So medical power of attorney is uh, where you designate an agent to act on your behalf if you're not able to. They can also, they will not take over your decision-making abilities. They will be there with you. They can sit there with the doctors. They can communicate with the doctors. But if you have the ability to communicate and you understand what's going on, then you are still in control of your medical decisions. But if it is a situation where you're incapacitated, and that could be a temporary incapacity if you're in a car accident, there you'll make a full recovery, but for that time frame, you're just not able to advocate for yourself. Your medical power of attorney will step in and uh, act for you and make those decisions for you. Um, and yeah, so that's, it goes into a lot of other things in terms of, you are in a long-term care situation that individual, your agent is able to kind of make those decisions for you as well.
So Lewis, does the financial power of attorney work similarly?
Yes. So the financial power of attorney is unlike treatment decisions, admission into and out of the hospital. Financial power of attorney addresses who can go down to the bank and deposit a check for you, who stands in your shoes to make investment decisions, helps coordinate taxes. You can even have your financial power of attorney sell real estate on your behalf. Um, well, some of the practical considerations are unlike a medical power of attorney. Let's say you're traveling. There may be some reasons you want your financial power of attorney to step in your shoes and make some decisions on your behalf. For a medical power of attorney, the doctors are always going to ask you, and we always start with you. But if you are unavailable just to, just to take a withdrawal, or maybe you need to do a required minimum distribution on a retirement account or something financial, it would be good to have someone you trust, someone who follows directions, someone who follows your directions specifically, um, take care of financial matters for you. So although there are related, and certainly the people doing these jobs are related, there's some separate considerations to work through.
And I take it that the same person doesn't necessarily be the financial power and the medical power. So they could be two different people.
They can.
Yes, and the other thing too is for folks who have children, more than one child in particular. Um, I've heard that oftentimes it's the oldest child who's selected to take on these roles. But sometimes maybe the oldest child isn't the right choice for a particular role. And what's your experience with that? And
Yes.
go ahead,
Yeah.
Lewis.
Yeah. So it's a great because I have people, they come into my office, we're getting the estate planning in place, and they say, my oldest is off in the sun. My oldest son, I want to make him the primary agent, or I want to nominate him in these roles, but I'm worried he might steal from me. I'm worried he might not follow my instructions. Does that mean he's the right person? And we take a beat, and the answer is no. You want to name the person that you trust to get things done the way you want. Remember, when we're doing all of this estate planning, and particularly while you're alive and have capacity, you are the boss. And so you want to name people who are going to follow your instructions. I'll give you kind of a silly example, which is Maybe you can't get to the bank and you want to deposit a check in a savings account. And maybe that savings account doesn't have a really good interest rate, but you just want it deposited into the savings account. If somebody comes and says, "Hey, I'm going to take this and I'm going to invest it in a CD that has a higher interest rate because financially you're going to make more money," technically that's not the job. The job is take the check, put it in the savings account because that's what you have told them to do. So whoever in your world can can follow your instructions, that's the right person. And obviously working through who that person is in a family with, maybe children who get along, don't get along, the oldest, may or may not be the right person. That would be something we would work together on to identify for each role who's the right person for this.
Yeah, I'd like to piggyback on that and say a lot of times the person coming in is concerned about hurting their loved one's feelings. You were
Yeah.
talking about the oldest, they're like, oh, well, they're the oldest, so that's how it should be. Or, I'd like to put the youngest, but that doesn't seem like that my family would like that. And it's not about what your family likes, it's what's best for your situation. And so really taking a hard look at family dynamics, I think is very important.
So Renee, along these same lines, so if someone becomes incapable of making a decision, for example, they're diagnosed with dementia or Alzheimer's, and their documents are not up to date. So how does that get handled for their spouse or for adult children?
Well, that's a very important consideration in preparing powers of attorney ahead of time, because once someone is incapacitated, then they no longer are able to sign documents. So they are unable to sign the powers of attorney naming or nominating their agents to act on their behalf. Therefore, you would most likely need to enter into a conservatorship or guardianship, which is an extremely time consuming and expensive and rather invasive uh, process, because it looks into background checks. It really analyzes the finances of the person being appointed. So if at all possible, get those documents in place prior to incapacity.
So thank you, Renee. So Louis, a related question. So separate from the medical power of attorney, how and when is a HIPAA document completed?
Yeah.
That's
So
the question.
yep, I saw that in the chat. So HIPAA, just that's the federal law governing the release of protected health information. HIPAA, the way I draft my medical powers of attorney, and Renee, I'm sure yours are similar. I actually have a provision in there that says whoever is named as the medical power of attorney is also authorized to receive protected health information. However, as a supplement to that, I also prepare a standalone HIPAA authorization that not only confirms medical power of attorney is allowed to serve in this role, but if there's anybody else that you want to be able to talk to doctors, for example, maybe your spouse is going to be the power of attorney, but you also want your kids to be able to talk with doctors, that would be prepared at the same time. At least in my practice, that's how we do it. I know different attorneys have different philosophies about that, but because hospital and particularly hospital administrators are so sensitive to privacy issues, and I think rightly so, we want to make sure that everything is consistent. And if you do happen to get a hospital administrator who doesn't think that the HIPAA authorization in my power of attorney works, we've got the standalone that addresses 99.9% of their privacy concerns. I would say you would do it at the same time.
Yes, I agree. Especially because sometimes the HIPAA, uh, well, perhaps the concern would be maybe a billing concern, and then you have a different financial power of attorney and the medical power of attorney. So there may be conflict there. So it's nice to have that separate HIPAA authorization where you name the financial power of attorney or anybody else that you'd like to handle things that are not necessarily specific to your medical condition. It just might be regarding the the billing or perhaps dealing with insurance. So I think it is important to have that separate HIPAA authorization as well.
Okay, thank you. Next question. So what is a living will and who should have one?
I'm happy to jump in on that. A living will, also known as an advance directive, this is the document that answers the question, when do we pull the plug? And in Colorado, there are specific situations where this will ever arise. It's pretty narrow. So in Colorado, what we're looking at is if two doctors in writing have certified that you have a terminal condition and you cannot communicate, terminal is defined obviously pretty broadly. Or the other situation would be if you've been diagnosed with a persistent vegetative state, that's brain death. And the idea is if you want life support removed, that is a medical treatment that you need to consent to. If you can tell the doctors that's what you want, then they will go ahead and do it, assuming you have capacity. But if you're unable to communicate your wishes, the doctors get in trouble if they remove life support without your consent. And so the living will advance directive captures your wishes before this situation ever arises. The likelihood of it arising, probably fairly slim. But then again, a situation could arise like that with Terry Schiavo from about 20 years ago. She was a young woman, I think in her mid-20s. She was in a car accident. She was brain dead. And her husband wanted the plug pulled. Her parents did not. And I think it went up to the Supreme Court maybe 3 or 4 times. 8 years later, they pulled the plug after hundreds of thousands of dollars of legal bills and medical bills. She did not have an advance directive. The advance directive answers that question. So you get to avoid all of the court processes. You get to avoid any conflict if family members have different opinions. Ultimately, we want to honor what your wishes are. And it just addresses a situation where you can't tell people in the moment.
And what I'm also hearing from that too is you've taken the time as a person to have a will, establish trust, have an estate plan, and then if you don't do that, then the chances are that chances are good actually that most of that money that you've given somebody or an organization or family member will be eaten up in legal bills afterwards. So
As I tell my clients, my job is to not get the lawyers paid. We do not want to be paying lawyers. We want to make sure money gets to your family and is protected. We don't we don't want legal fees. That's what we're trying to avoid.
yeah, okay. Um, okay. Now I'm going to ask, I have a few questions on Medicaid because Medicaid does come up pretty frequently. So I guess I'll address these to Renee and Lewis. If you have anything to add, please do. So how does Medicaid planning, and what is Medicaid planning, by the way, fit into the broader estate planning picture?
Sure. So when we're talking about estate planning, we're talking about Medicaid long-term care rather than just the Medicaid for younger folks. This is age 65 or older, and in you're needing nursing care level care. So that might not be within a facility. It could even be at home, but that's the requirement, age 65 and nursing home level of care. Excuse me. So I think everybody is well aware that long-term care is getting increasingly more expensive. I think a safe average is to say $10,000 a month, which, some people can afford and many can't. And it is a real consideration about, private pay, and then you might be out of money. And so planning ahead, I think, is a very important here, because the income and asset limitations to qualify for Medicaid the thresholds are extremely low. It's the asset limit is 2,000. So if you have more than $2,000 in assets, and that does not include your home and a few other assets, but for the most part, any money in bank accounts, IRAs, retirement accounts, that you can't have above $2,000. And then the monthly income, I don't remember exactly what the number is, but it's roughly 2,850. I think it's actually 2,842, but so that's your monthly income, and that includes, if you have a job, but it also includes your Social Security payments. And so a lot of times folks are above that limit, and they think that they're unable to qualify because maybe they're receiving $3,200 a month, and that's not necessarily the case. There are options there, and rather than just trying to figure out how to qualify and pay for monthly care at $10,000 a month when you're making $3,200. So there are still a lot of options, even if you are above those two minimums, that 2,800 and the 2,000 in assets. So the sooner you can plan, the better, because Medicaid does have a 5-year look back period on any transfers out of your name. So, you're giving the grandkids a gift of, for college, then 2 years later, you're applying for Medicaid, that gift would actually count against you, even though it's not currently in your estate. So, if we have 5 years, that's ideal. But again, that's not necessarily always possible to plan that far ahead. But it's, planning for Medicaid, I think, is a very real consideration, and you don't have to be impoverished to do so. I think a lot of times people also think it's unethical to, I can't, if I can private pay, I should private pay. But you've been paying into the system, and you're not required. I mean, there's countless cases where they've said, the Supreme Court has said, you're not required to pay more than you need to. Planning is a strategy available both to people, to wealthy people, as well as people without means. So it makes a lot of sense to plan ahead and take advantage of all the resources that are available to you.
Okay, thank you. All right. I think you covered the eligibility requirements and proper planning, and planning is a key word here today.
It is.
Plan ahead. So, Louis and Renee, both, what are some common misconceptions about estate planning, special needs planning, and Medicaid planning? All three of those things. So, you want to start, Louis?
Sure. So, I will admit I don't do Medicaid planning specifically. That's a subspecialty, and generally when folks have Medicaid planning issues, I would refer them out to someone with experience like Renee, who does that sort of work. As far as estate planning, and certainly as far as special needs planning is concerned, a lot of folks come into my office saying, hey, we're not going to donate a wing to the Denver Art Museum, so we really don't need an estate plan. And I just always point out to people that your legacy, you don't need to have your name on the side of a sports arena to leave a lasting legacy for your family and your loved ones. Fundamentally, we're trying to make things easy for everyone in a potentially difficult, fraught time. And estate planning can address emergencies that we hope never come up, but life sometimes throws us a curveball. That's what estate planning fundamentally offers. I think people have, visions of the monopoly man in their mind when they think about estate planning. And it's just, how do we get help for you and your loved ones, regardless of the amount of assets at issue? I work with all sorts of folks. There's no minimum at my practice. Um, it's just a matter of, are you looking, the estate planning is appropriate for anybody who wants to solve problems before they happen. I happen to work with nice people as well. So if you're nice, that's a good bonus. But certainly, if you want to solve problems before they happen, that's the estate planning conversation.
Renee, anything you'd like to add?
Absolutely. Problems before they happen. We were talking about the powers of attorney. If, someone becomes incapacitated, and obviously, if we're talking about dementia, then you can see that's coming down the line in the future. But a lot of times you can't see that. Someone might be in a car accident. Someone you know, could have a stroke and suddenly they were fine one day and then the next they're not able to communicate, they don't have the mental capacity to sign any powers of attorney. And at that point in time, your options are limited. You're reacting instead of, just planning ahead. And I think making a plan, uh, whether we're dealing with significant assets, or if it's just a modest estate where it's really the only asset is the house, then there's still an asset there. And but really, I think it's about naming those key people to step in and make sure that your wishes are respected, and you are taken care of in the way that you'd like to be taken care of, and that your assets are distributed in the way that you want them to be. The people that are important to you get the things that you've worked hard for.
So let's talk about trust again for a second. So you mentioned, Renee, maybe a person only has their home as their only valuable asset. So why bother to set up a trust, for that? And then, and we had another question kind of related to that. And does a trust reduce the need for an executor of your estate? So do you want to start with that, Renee, and
Sure.
then Louis?
So if you only have a home, if it's jointly owned with your spouse, then after the first spouse passes away, the surviving spouse is the sole owner. But I think having a trust for a home is important for several reasons. One, as I was talking about earlier, Medicaid, if that house is owned in the trust, that is not part of your probate estate, and that will transfer outside. It will transfer through the trust. So the home would not be subject to potential Medicaid recovery. It is also just a more streamlined approach. I think just the trust is just uh, it is more expensive, as Lewis had mentioned, obviously, but I think the additional expense compared to what you're getting for it, your loved ones don't have to try and figure out how to transfer the house. If it's just if it's not in joint tenancy with your spouse or someone else, then it would be subject to probate. It would have to go through probate to be sold, and excuse me. So, I think it's a lot easier if there's only, even if that is only your only asset. And then the question about does having a trust reduce or eliminate the need for an executor? And the answer to that is actually no. In Colorado, the term is personal representative, but executor is it's interchangeable. That's the person that's appointed in your will to act on your behalf, to step in and close out your affairs and If there are probate assets, then, pull them into the estate and then make the distribution. Even if you don't have a will, then somebody will still need to be appointed to make those distributions after you've passed away. So there's still somebody who's going to need to be appointed through the probate process.
Louis?
I think that's all. I think that's all well said. I guess the only thing I would add, or maybe the only thing I would add is that if your estate plan, if we use a revocable living trust to organize your estate plan, then hopefully we are avoiding the probate process and we would not formally appoint an executor. But as Renee said, the role under the trust is practically the same. Somebody, and I call them administrative trustees, the administrative trustee has to administer the trust, meaning tie up your loose ends, pay a final income tax return, retitle the house or maybe sell it, retitle retirement accounts, bank accounts, etc., pay off final credit card bill. That is the exact role that an executor does. So it just depends on how you do it. Are you going through a revocable living trust, or are you using a probate proceeding and going to court? The job itself is the same, even if the labels are different.
Yes, and to follow up on what you were saying with retitling all of those assets, and something you'd mentioned earlier of if somebody comes in and they've moved from another state, I think it's really important, and that shows the importance of keeping the trust up to date, keeping it funded properly, because a lot of times folks will set up a trust and then fund it initially, but then 10, 15, 20 years go by. They've now bought and sold houses, they've opened up new investment accounts, and their original plan was one thing, and now they're saying they have these other accounts that maybe don't have a beneficiary listed. So instead of going into the trust, it would go into their estate, which then would necessitate the personal representative being appointed. And so I think it's critical to make sure all of those accounts and everything is up to date with the trust.
Okay, thank you. Here's a really interesting question. So another interesting question. So how can I ensure that my children will not squander their inheritance?
Mm,
You want to
mm.
start with that one, Louis?
Sure. That is an interesting question. I think all family, you can answer this question a little bit differently depending on the family's dynamic. I don't have a general answer for you. I will tell you though that there are some things that obviously you can do while you're alive to the extent that you want to kind of reinforce good money management, investment habits. If you do work with a financial advisor, maybe bringing your children to some of those meetings, if you think that's appropriate to kind of see how these conversations go. If you don't want them involved, if it's none of their business, that's totally appropriate too. Um, After you die, there are certain structures that we can set up, or we can have them set up, and then when you die, they actually hold assets. And those are known as testamentary trusts. And they have rules that would govern when your children are allowed to receive money, if at all. Some people say, hey, no one gets direct control of anything until they turn 50. I think that's a little old myself, but um, that's certainly a way that you can do it. There are a lot of different speed bumps and roadblocks and guardrails, whatever the term you want to use, that we can build in so that your kids don't blow it all in Vegas or buy a Land Rover or buy a penthouse and then the money's gone. Um, and it depends on what's the issue with the kid. Is it a substance abuse issue? Is it just financial immaturity, which will be solved through the process of growing up, hopefully? Is it a spouse? And we're a little worried about a divorce proceeding. Are they in a high liability area or profession like a surgeon or construction? Are we worried about third party lawsuits? depending on what we're worried about, it's a lawyerly answer, I'm sorry, but depending on what we're worried about, there are different solutions to solve it.
Okay. All right. That makes sense. Um, but and I know those things do get solved. You see these things on TV shows all the time, well, this kid, is a ne'er-do-well. He can't have any money until he's 65 years old or whatever. So we had a question here about what happens if the executor of an estate is not doing their job? Are they liable or what? So Renee, you want to start with that one?
Sure. The executor is a fiduciary position, and that means they owe a duty of care to the beneficiaries. And so um, they, the potential ramifications of them not doing their job, whether it's their just not making those distributions, they're dragging their feet, and then maybe the house is just sitting there, and they missed the window, kind of that summer sales window, and they ended up losing $10,000 on ultimately on that sale of property because they ended up having to sell it in the fall. They might be personally on the hook for that difference in the excuse me, in the assets value. So, I mean, it really is important for that personal representative to, maintain contact with the beneficiaries, let them know what's going on, and also make those distributions and protect the value of the estate.
And Lois, if they don't do that,
Well, if they don't do that, depending on what job they're not doing, a judge might hear about it and they could be in trouble. Um, it depends. Are they moving slowly? Are they wasteful of estate assets? Are they committing some sort of fraud or something that might rise to the level of criminal liability? Are they stealing from the estate? I mean, there's a lot of ways to answer the question, what are they not doing? And then of course the next question is it worth hiring litigation counsel to potentially prepare the case and have a judge hear it? um, that would all be very fact dependent, circumstance dependent, on what the issue is and how much money is at stake.
so Renee, would you recommend setting up a payment or compensation plan for an executor?
Well, I think at least in the documents that I prepare, there is that there is that ability to have compensation for the personal representative. They're reimbursed for their own expenses out of pocket, but there also is an ability to have them compensated. And again, that lawyerly answer of it depends. If it's kind of simple, just making, distributions, there's just a couple of bank accounts or investment accounts that have been liquidated and now they have to write a couple of checks, then, they probably don't need to reimburse themselves and to compensate themselves. But if we're talking about having different types of assets, such as real estate, commercial real estate, perhaps agricultural or something that's difficult to value, and we have to bring in valuation specialists and then pull in all of that. Maybe there's some work in finding beneficiaries. So the more work there is, obviously, it is very time consuming, and that might be a situation where the personal representative would want to consider compensation or being compensated. One thing I always point out to people is that compensation is taxable. So sometimes they want to, compensate that personal representative or executor and say, oh, they'll have $10,000 in compensation. That $10,000 would be taxable to the personal representative as it is earned income.
Okay, thank you. And one last question. We got 3 minutes left here. So, and start with you, Lewis, on this one. If you have minor children and you become incapacitated, what are the considerations and arrangements that you would ideally make before a tragedy struck? How would you handle that?
Yeah, I think you have to work through who is going to be the surrogate parent if you're incapacitated or if you pass away. This is known as a guardianship, and that's the person who's going to get them to school on time, make sure they're clothed, fed. Um, that you can do on a temporary basis and that you can also do in your estate plan documents, such as a will for a more permanent position. And then the other thing is, and kind of separate but obviously related, is for your children, who is going to manage their inheritance? If you're a minor in Colorado, you're not allowed to put anything in your pocket. And if you don't have anything in place, a court will set up something known as a conservatorship. Um, it may or may not be the person that you want managing the money, and all the money goes to your children when they turn 21, regardless of if they're ready or not. 21's pretty young, I think, to be managing any inheritance. So your considerations are who is going to help your children, who's going to help them manage the money. Is that the same person? Is it different people? And would they work together? And then what are the rules that you would want to set out for when your kids, if and when your kids receive things? There's all sorts of different ways to set that up. But, I think as I tell most parents, you want to think about this, you at least want to think about this once or twice. And odds are what'll end up happening is I'll talk with you again when your kids are graduating college, getting married for the first time, and we will update this to address new situations because hopefully it won't be an issue. But you definitely, at nothing, the foundation, the floor is who is going to be my children's guardian? Who's going to get them to school on time, clothed, fed, sheltered? And do they need to move in order to do that? Are they going out of state to be with other family members? What does that conversation look like? That needs to happen.
Okay, thank you. Renet, do you have anything you'd like to add?
No, I think that's really important. I would, I guess, add on, make sure you talk to these people that you're appointing guardian or as potential guardian. I think that's oftentimes a situation where people are like, oh, I'll name my brother because he's just the logical one. But you really haven't factored in, okay, maybe he's single and he lives out of state or whatever the case may be. So you really want to think on this one very carefully. And it's also this person might change and probably will change as your children get a little bit older. So make sure you're updating those documents as well, because it might be you named your best friend and then 5 years later you're no longer close with them. So it's very important to keep that one up to date.
Okay. All right. Well, thank you so much, Renee and Lewis. And this has been a great session. I've learned something new again today, so I always do. So I always appreciate that. And thanks to everyone who joined us today. And we have recorded this, and we will get this on our website in a few days. And please let your friends and neighbors know about it as well. And have a great afternoon, everyone. Thank you so much. All right, take care. Bye-bye.